Good morning, everyone, and welcome to this CPD session on subpoenas. It's taken a bit of time, I think, to admit everyone. My associates are normally good at admitting 4 or 5, 6 people maybe in a court hearing, but today we've got about 260 people that were wanting to join. So thank you to Adam and Rabia for doing that. Today's session is intended to be really practical, so hopefully Judicial Registrar Gary, in running through the subpoenas overview, will answer the questions that you have. If I could just, if anyone's got questions, send them through to the chat function and we'll try and allow time for them at the end. But I know Jim has got a lot to cover, and as I said, he's prepared it to be as practical as possible. So hopefully questions that you've got will be answered along the way. But let's get moving. So I'll hand over now to Judicial Registrar Gary, who will speak to you about subpoenas.
Thanks, Andrea. Good morning to everybody. I'd like to start by first acknowledging the traditional custodians of the land where we all meet today, and pay my respects to elders past and present, and to any Indigenous persons who are with us today. As Judge Salamanders has said, today is designed very much to be a practical examination of subpoenas. Subpoenas are very important from a case management perspective and case preparation, and they also will assist greatly for you in obtaining the best outcome for your client. Now, this is not meant to be an administrative discussion today. I'm going to concentrate very much upon the rules. The purpose of today also is to assist you with what we believe is that there are a large number of you who may never have had the advantage of having any training in the areas of subpoenas, and we hope that this will assist you. Also, now that we are moving towards more and more practiced court matters, such as directions hearings and objection hearings being by way of audio-visual means, it means that you often don't now have the advantage of sitting in the courtroom as you would have prior to the audio-visual links, and you would have an opportunity to hear and observe what is going on in matters before you and have that learning experience. I'll start with what is, I consider, the 3 crucial resources to assist you in understanding the rules and procedures in regard to subpoenas. In fact, it's not just limited to subpoenas. It should assist you generally in the rules. The first is the County Court Civil Procedure Rules, and this is the first. The second is the County Court Subpoena Practice Note.
Got something to ask.
And in that regard,
notice of things out of date.
Excuse me, I've got.
Yeah.
Somebody turn off their microphone.
I mean, the client says my fault.
Yep.
We've got persons. Everybody, please ensure your microphones are on.
I can deal with idiot clients.
Thank you.
If the letter to remind him of the 20th of May date.
I'll continue, but I'm hoping that that's not affecting persons.
Did a letter to him, but we do a letter.
Good, thank you. As I said, the first is the County Court Civil Procedure Rules. The second is the Subpoena Practice Note, and as you'll note from the PowerPoint which is being shared with you, that's to be revised, but a lot of what we'll discuss today will be in the revised Practice Note. The other is the Common Law Division Practice Note, and I remind everybody that there is a recently new published Practice Note, and that you should familiarise yourself with that. And the last is the subpoena. That is the subpoena document itself. And often you'll get a great deal of information from the court documents themselves. And I'll make reference today, this morning, to parts of the subpoena documents that can help you. Now, the starting point from a subpoena perspective is what you want.
Sorry, Your Honour, you've just gone on mute.
I'm off it again now. Can people hear me now? Can you hear me now, Adam? Thank you.
That's better.
There are 2 types of subpoenas. The first is to trial, and that is the slide, the next slide that should come up on for you, which is to trial, which is an Order 42 subpoena in the rules. And then the second type of subpoena is to the registrar. Now the rules make it very clear in the heading. One is to trial, one is to registrar. So you can issue a subpoena either under 42 or 42A. Now, under 42, they're to either attend court and give evidence at trial, or to produce material and documents, or to do both. Under 42A, it is limited to providing material to the registrar. Now, there's an important reason to make sure you distinguish between Order 42 and the forms of the subpoena. Under Order 42, and you'll see I continue to emphasise to trial, there are 3 subpoenas, as I've said, but they are referred to as a Form 42A subpoena, which is to attend to give evidence. The one to produce is the 42B, and it's Form 42B. And to attend and give evidence is Form 42C. So Order 42 subpoenas are Form 42A, Form 42B, and Form 42C. Now, we then look at what is the Order 42A subpoena, and that will be the next slide. And to help you or confuse you, the term of that is a Form 42AA. And again, I emphasise that because if you look at Order 42A, you would look at the forms and think, well, that's a Form 42A, but it's not. It's a Form 42AA subpoena to registrar. So it's very important then, when you're looking at wanting to issue a subpoena, that you ask yourself 2 questions. And the first is, what do I want the material for? If it's material you're after, is it for trial or is it for pre-trial? And that is to the registrar. And then you determine the type of subpoena that you issue. We get a large amount of wrongly issued subpoenas. And that will be subpoenas for trial are often Form 42AA and vice versa. That we'll get Form 42A subpoenas issued when parties really intend it to be a 42AA. So for your guidance and assistance, I'm hoping that by clarifying why you issue it, that is, are we issuing it for trial or pre-trial, that will help you to go to either 42 or 42A. Now I'm now going to turn to the Order 42 process. Now, today, as I indicated, is very much about the rules. It's probably not the most exciting thing you're going to do today, but it is something that is very, very important from your learning perspective, but also to assist you, because the rules themselves can be quite complicated, as you'll see when we go through and discuss them. And the rules clearly separate a process for Order 42s to trial subpoenas and 42A or AA subpoenas. So there's a clear difference and process to be followed for both. So if at the end of the talk you say, I don't want to hear him say again to trial or to registrar, I'm happy, because it means I've got that clearly in your mind to differentiate, because then you'll go automatically to what is the rule that you need and the process to be followed. So we'll start with 42, which is to trial. Now, remembering that it's to trial, and again, the rules differentiate under 42 and 42A on terminology as to who has the control in relation to subpoenas if there's an objection or application to set aside, etc. In 42, it refers to the court. In 42A, it will refer to a judge, an associate judge, and we don't have an associate judge, or judicial registrar. We interpret the difference between the two as being an intention in the rules to differentiate and make clear that the 42 process is very much designed, because of the nature of it to trial, to be managed by the trial judge. And that's the right reason the wording of the rules refers to the court, as distinct from judge, associate judge, or judicial registrar. So looking at 42, which is the setting aside, and remembering that this is a subpoena that you've issued for a party to attend to give evidence or to produce evidence at trial. And the rule provides a process by which, and as it's set out in 4204, the court may, on its own motion, or on the application of a party or a person of any who has a sufficient interest, to set aside the subpoena in whole or in part, or grant other relief. That's the process. For example, if a person got served with a subpoena to attend the trial and they wish to object to attending, that is the process by which they would follow. But it also provides a party to the proceedings an opportunity to seek to set aside the subpoena. Any application which you make under 1, paragraph sub-rule 1, should be made on notice first to the issuing party. And then the court may order the applicant give notice of the application to any other party. So if, for example, a witness was to apply to seek an order to set aside, the court can in that instance, and would in that instance, notify another party of it. So that process allows an opportunity for a person to set aside. It's important to remember that a subpoena is issued at the request of a party. Subpoenas are not issued by the motion of the court, it's by a party who seeks to issue the subpoena. If there are any issues regarding the subpoena prior to trial, those issues really are the responsibility of the party issuing. They're not the responsibility of the court. The court will often get calls from persons served with a subpoena saying, we've been served a subpoena, it says we've got to be at court next Tuesday, I can't be there, I'm going to hospital for some reason. That's not the responsibility at that time of the court. It is the responsibility of the issuing party. And it's important for practitioners who issue the subpoenas to realise you're the one seeking the material, you're the one seeking the person to attend. And if you remember at the beginning, I mentioned that a valuable resource for you is the document itself. If you look at the Form 42A subpoena, at the bottom of it, it says details of subpoena. And it says, you are required by this subpoena to attend, to give evidence, and you must attend as follows, unless you receive notice of a later date or time from the issuing party, in which case the latter date or time is substituted. The form itself, the document, says clearly the responsibility rests with the issuing party. But it is also important from a practical point of view how you deal with the witness, because if you're subpoenaing a person to give evidence at trial. You issue the subpoena for the day of the trial, but you may not call that person until the second or third or fourth day. Good practice should be that you've communicated with the addressee before the trial. You've informed the addressee that they will be attending. You've informed them, hopefully, that they may not be required on the first day or the second day or whenever, and you keep in contact with them. Otherwise, the person gets the subpoena, attends court and sits around for 3 or 4 days, and remembering that you've got obligations under the Civil Procedure Act, and those obligations including the way how you deal with court time and persons involved in proceedings, and your obligations under professional conduct rules. So you should communicate with the person beforehand and have that conversation. And if there's any problems or issues, you should attempt to resolve them. If that becomes an issue at the time of trial, then you raise that with the trial judge. So it's very important that, and you also don't want to have your witness offside. So you want to be at least on very good terms if you can with the witness beforehand. You don't want to upset them before you call them by having them sit around unnecessarily when they may not necessarily be required. But that's the responsibility of the person. Now, the setting aside and relief is, as we've just discussed, how the application is made, etc. I now turn to compliance, which is 4206. Now, in the regard to compliance, I'm really concentrating for your benefit here at the production subpoenas, which is the 42B, occasionally the C, but more importantly the B, which is where you're seeking production material to the trial, as distinct from the attendance of the person, which is what I dealt with previously. Now, Subrule 4 talks about the compliance by the addressee, the person served with the subpoena. And it says that the addressee can comply with the subpoena to produce by either attending at the date, time and place, which is the trial date, and producing the documents, or by delivering or sending the subpoena and the material to the registrar at least 2 cleared days before the production date. Now, I talk about that purposely because, again, not to confuse when you look at the rules, that rule with the 42A to registrar process. So a person served with a Form 42B subpoena to trial for material can produce that material before trial. And it needs to be done at least 2 clear business days before the trial date. And then the material will be held by the court. Now, in that instance then, the rules provide, as we'll now discuss on the next slide, under 4209, the rules provide with a process for the inspection and dealing an objection with that material. As I said, I'm going to hammer the point. This is to trial. This is not the process to the registrar. And the rule is 4209, as I state. So what that says is a couple of things. Subrule 2 firstly talks about the production of the material. And what that does is it allows you the opportunity to find out, was the material and has the material been produced to the court? So Subrule 2 says, on the request in writing of a party, the registrar shall inform the party whether the production in response to the subpoena has occurred. That provides you an opportunity to contact the court and say, is that material here? Has that material been sent? And you should do that. You should make sure that the material is with the court if you're seeking material for trial. But Subrule 3 imposes a restriction on access to that, and leave to inspect it and copy any material has to be done by the court. You can't access that material without leave of the court. Again, if you remember, I talked in terms of the court, and again, the wording is unless the court has granted leave. It doesn't say judge, judicial registrar. So again, we interpret that very much meaning that it's the responsibility of the trial judge who grants leave to inspect it. And then there is a provision which allows parties to inspect it, subject to any orders that may be made. But there's not an automatic right to inspect the material unless there is leave granted. So it may come in early, but it doesn't mean you can go and inspect it under the 42 process. And then if we continue on to the next slide, which is continuing this process, there is provision for the addressee to also object. Remember that we talked earlier about setting aside a subpoena, but this is an objection process now that is provided to an addressee to object to the material being produced at trial. And that's Subrule 5. If an addressee objects to a document or thing being inspected, the addressee shall at the time of production. So that's when the addressee's objection's made, and the addressee has to notify the registrar in writing of the objection. And again, if you look at a Form 42B document, the form itself, it says clearly under the heading, and if you read down the document under notes, you look at number 11, it says applications in relation to the subpoena. You have a right to apply to the court, A, to set aside the subpoena, or in respect of, for any order in which you claim privilege, public interest, meaning confidentiality, the subject. So it provides, again, the addressee who's served with it what to do, but it also provides you with that guidance in relation to that. Now, if an objection under this rule occurs for trial, as Subrule 6 talks about, the objector may notify, as we said, in writing and the grounds of the objection. Now, upon receiving that objection under Subrule 7, that prevents any inspection of the material, so it should not permit any further inspection, and it's to be then referred to the court. So in other words, the process is objection lodged, the registrar notifies the judge that there has been an objection raised. Now, I'm also going to refer you to Rule 42.12, which is the next slide. And that's a failure to comply with a subpoena. And a failure to comply can be contempt of court. So I make reference to that for a couple of reasons. The first is, clearly, it's important to remember that the subpoena being issued is an order of the court. The failure to comply without lawful excuse can be contempt of court. So it's quite serious, and an addressee will be dealt with accordingly. Which goes back to what I said earlier about how you communicate with an addressee, your assistance in providing when to attend or whatever, because the consequences of non-attendance can be quite severe. Equally so, if you have an uncooperative person, it should be raised with the trial judge that they're not complying and not attending or responding, after proper services subpoena, and there is provision there in regard to the judge dealing with the person by way of contempt, if necessary. But it also brings to the very relevant point of orders of court. And I digress a little bit here generally to talk about that there is an increased tendency for people just to ignore court orders, timetabling orders and whatever, because it's just a timetable. What they're forgetting is it's an order of the court. And the fact that in Order 42, there is a clear provision in the rules which says if you don't comply with this order, you can be in contempt of court, I think is a very good reminder to people about the importance of court orders and compliance with court orders. But that process for non-attendance or not providing and whatever will be a matter, again, that the trial judge will deal with. So 42 is designed for the trial. It's a subpoena issued by you. You manage it up to the time of trial. It's to either attend to trial or produce material. And if there is an objection process both to the subpoena, there is an objection process to material, and they will be all dealt with by the trial judge. I'll turn now to the 42A process. And the 42A is probably the one that you will deal with most, because that's the pre-trial, pre-discovery, pre-early return subpoena process. And I'm suspecting that that's the area that you'll have some of the greatest problems with, and can also be the area that can be most beneficial for you in the way you prepare and obtain material for the purposes of trial. So, as we've said, this is a process which allows you to get material early. It's not to be used instead of discovery, and it's a process that we strongly recommend in serious injury matters, because it allows you to have a look at the material well before the trial. I'll talk shortly about some of the issues that arise under the rules and the court orders for inspection. But one of the frustrating areas is where 42A subpoenas have been issued some months before a serious injury matter, and in a day or two out of trial, there's a desperate rush to look at that material which has been sitting with the court for months. It defeats the purpose of an early return subpoena. Why issue an early return subpoena and look at the material months later? So it is very important for you to appreciate that there is a provision in the rules that gives you an opportunity to look at this material early. But equally so, as I've said, the process has got a slightly different rule formatting and process to a trial process. And with an early return subpoena under 42A, an objection can be lodged by two persons. The first is the addressee or another person of an interest, or the second is a party to the proceeding. And the rules provide for a very separate process to go through for the objection of documents. As I said, when you look at the 42A subpoena, there are under notes, it provides material relating to the process for the benefit of the addressee. It also has a production date when the documents are to be produced by the addressee to the court, and it sets the manner in which the addressee is to comply or object. Now, I want to deal with the objection process in some detail if I can, and in particular to take you through the wording of the rules, because this is not, the wording can be quite not misleading. It just can be reasonably difficult to fully understand what the steps are. So I'll try to take you through those steps if I may. So we'll deal with firstly an addressee objection. And again, we emphasize here that it's just not a party who can object. And that's important because persons will often say, well, there's been no objection by a party, so we want to see the material, but an addressee can object. Now, 42A07 provides the process for an objection by an addressee. And it says that the addressee has an objection to producing a document or being inspected, or a person who has a sufficient interest other than a party may object. And if they do, they are required to notify the registrar in writing of that objection. And they must state the grounds of that objection before the day specified in the subpoena. The day specified in the subpoena is the return date for the subpoena. So if an addressee or another person other than a party wishes to object, that objection has to be in writing to the registrar, and it has to be by the date specified in the subpoena. If you're the party that's issuing the subpoena and an objection has been taken by the addressee, it's most important that you see what is the grounds and what has been sent in. The rules provide for that process. Sometimes you don't see it, and it is very important you know exactly what are the basis or grounds of the objection. Because in some instances, the grounds of the objection may not in any way cause you a difficulty. For example, and this is probably the most common one we often see, where in serious injury matters, a subpoena is issued to the Victorian Work Cover Authority for files in relation to previous claims. The claims agent sends in the material, but says, we actually have taken off from the material some advice letters we received from our lawyers, and we claim privilege over them. Now, as you'll see shortly when we discuss the objection process, once an objection is lodged, that actually freezes access to the material until the objection is dealt with. But in most of those cases, you don't want to see the advices, you want to see the file. So we try to deal with those ones on the papers as much as we can by communicating with the parties and saying, look, here's the objection letter that's been sent in. It's only privilege that's claimed over 2 advices. Are the parties happy to examine the material? And sensibly, their parties come back to us and say, yeah, we don't want to see those. We just want to see the rest of the material. So it's very important that you see what is the grounds and the reasons for the objection. Turning now and continuing on the objection process, I now want to have a look at the objection by a party. So that's sub-rule 8. And it says, and there's 2 parts to sub-rule 8, and paragraph 2 is the very important part from a plaintiff lawyer's perspective in relation to the medical material for your client. And I'll come to that in a moment. But what paragraph 1 says is subject to paragraph 2. If a party has any objection to the inspection or copying by another party of a document identified, the party having the objection shall notify the registrar in writing of that objection and state the grounds of that before the date specified. So the objection has to be done prior to the return date of the documents. That can create problems, as we'll come to in a moment. But it says that the objection is to be before the date specified in the subpoena, which is the production date. If we now turn to subparagraph or paragraph 2, If a party other than the plaintiff seeks by subpoena the production of any hospital or medical file or record, and we interpret Medicare records as record, concerning the plaintiff or the plaintiff's condition, the plaintiff may, before taking objection under 1, inspect and take copies of the file or record produced to the registrar and notify the registrar thereafter of any objection. And it has a 14-day extension over the production date to do so. And the grounds of that objection, it says, in writing within 14 days after. What subrule 2 or paragraph 2 gives then is a plaintiff an entitlement to inspect automatically the material in relation to the plaintiff's medical condition that might be subpoenaed by a defendant, for example, and gives a further 14 days beyond the normal production date in which to do so and to lodge an objection. Very few persons take up that opportunity. Instead, what happens is they lodge an objection immediately. As soon as the subpoena is issued, objection lodged. They haven't looked at the material. They don't even know what the material is. And then when it comes to hearing the objection hearing, they haven't got anything much they can say because they haven't looked at the material and they don't know what they're objecting to. So the rules provide for a great opportunity for plaintiff lawyers to look at that material, examine the material beforehand before objecting. And that's sub-rule 2. So very important for you to remember and look at that. Turning then to what happens then if there is an objection. So whether it be by a party or an addressee, once the court receives an objection, the registrar has to refer it to judge, associate judge, or judicial registrar for hearing and determination of the objection. So in practical terms, what happens as soon as an objection comes in, it's referred to me. And that has to be. There's no choice in the matter because the rules require that. Paragraph 2 is very important. The registrar shall notify the issuing party in writing of the objection. So it's the party that issues the subpoena that the registrar is required to notify only. In practice, we notify the parties, but in strict interpretation, the registrar has to only notify the issuing party and the grounds of that objection, and then the time and place at which the objection will be heard. And that party shall notify the addressee and all other parties accordingly. The obligation is on the issuing party to ensure that the addressee and other parties are aware of when the objection hearing is to be heard, and also to inform the other party of what the objection is. So in practical terms, defendant issues a subpoena, addressee objects, sends in an objection notice, the registrar notifies the defendant, says, here's the objection, solicited for objection hearing on this date. The defendant should be notifying not only the addressee of the objection, but also the plaintiff, and also providing the plaintiff with what is the objection. Now, we then go to the inspection. And this is the rule that effectively stops anybody looking at any material when an objection is lodged until it's dealt with. And that's A10, 42A10. And what that says is, if no objection is notified under 42A07 or 42A08, so in other words, no objection by a party or an addressee or other person, or to the extent of such an objection is disallowed, each party, unless a judge, associate judge or JR otherwise orders, may by appointment inspect and take copies. There's two sides to that rule. The first is, once there is an objection, no party can look at it till it's dealt with. The second is, if there is no objection by an addressee or a party, you have an automatic right to inspect and copy the material. You don't need a court order. You don't need to bring any application. It's an automatic right that follows once, if there is no objection under the rules. And that's very important to remember. Now, conscious of time, so I'll try and keep pushing ahead a little bit. I haven't got too much more to go, but I do want to keep moving through some of these processes because it's important. So when then you will see that we have got an objection which has been issued, and there has been the process which we've talked about here, the court will give you a date and the objection process then is required to be heard. But there is no choice that the court has in relation to preventing access to the material because of 42A10. But it also emphasises the importance to plaintiff lawyers, when it's a plaintiff's own medical material, to examine that material and use the benefit that's given to you under the rule when that material has been produced. I point out here also that sometimes materials not produced by the production date. And that causes a problem because the rule on a strict interpretation suggests that you have to lodge your objection by the production date, but you haven't seen the material. So how can you really lodge your objection? What we recommend there is that if the material's not being produced by the production date, you lodge an objection to the non-production of the material. And we will record that as an objection, which is the practical way we try to deal with that issue. So it doesn't preclude you bringing an objection if you have to later. Now, the next thing that I really now want to do, if I may, is raise some talking points which may trigger us some questions or answers for you about what we've discussed. So the first one is that as part of the regular timetabling orders, an order might read, by X date, any subpoena under 42A is to be issued. We're often asked, does that impose a deadline on issuing all subpoenas? And the answer is no. It is only in relation to 42A. It doesn't impose a deadline on a 42A or Form 42B and C. They're governed by the rules as to the time period. And if the time between the required issue date and the trial date is insufficient under the rules, then a short service application should be made. But for 42A, we make that order specifically that is to be issued by that date. And there's a very important reason for that as well, which I'll cover shortly in the second point, but I'll state it now, which is because of the objection process that we've just discussed. That is that a party can object and that an addressee can object. And because the court has to deal with that objection before we can release material under rules, we have to allow about a 6-week period between an issue of a Form 42AA subpoena and for that process to be completed. So you'll note that in the court orders, we are making now, and particularly under the new form of order for juries and causes attached to the new practice note, subpoenas will need a minimum of 6 weeks before any trial date under 42AA to be issued. We won't allow them under that time frame because we cannot deal with the subpoena objection process. But also, the reason we want that early is because the material should all be available, and you should have all that material in the case of causes and juries before you mediate and before serious injuries, so it's all examined well before trial. But that order only applies to the Form 42AA subpoena. The next question, which I've to some extent already answered, which is the 42AA short service. We get asked, can you get an order for short service of the 42AA? And the answer is no. You can't, for the reason I just explained. You need 6 weeks. You can get short service orders for 42A, B and C, Form 42A, B and C. That should be by application to the court. It should have an affidavit supporting it, setting out the reasons why, and it should have a draft order. And that should all be sent to the court. But not for 42AA. The next question that's often asked is what happens about an objection which is out of time? So, and it's often not realised. The number of times that I've had objection hearings where the objection sent in by a party is not before the return date, but no persons have picked it up or no issue has been taken. But what happens if you want to file an objection and you're out of time? Usually it's just a day or two and no inspection is taken. And remember, if you don't file an objection and the addressee has not filed an objection, then the problem is that material is available for the parties to look at. And what I recommend you do in those circumstances is that I would communicate with the other side, see if they take any issue with it first. And if they don't take any issue, file it. I just wouldn't file the objection and hope that everything's okay at the objection hearing. But if they object, then you can apply to the court for leave to file an objection out of time. And issues of prejudice and whatever would be considered. Now, the next question is the inspecting 42AA material. As I've said, if no objection's taken, then all parties have access to it. So I reiterate that but if there's an objection pending, you can't examine the material. And you will also note that I've added in there, practitioners be aware of the 30-day order for inspecting serious injury matter. In your serious injury orders, it'll say to inspect 42A material within 30 days of the serious injury trial date. We do that for a very important reason. Often the material has been sitting here, as I said earlier, for some months and not examined. But more importantly is practitioners often will communicate with the court a day or two out from the serious injury, wanting an inspection. And it's just a practical consideration of the need to get people to look at that material at the last minute as to a resource issue. And it's important to remind practitioners of their obligations, again, under the Civil Procedure Act, but also we don't want a trial delay. We don't want a serious injury delay because practitioners have not looked at this 42AA material that's been sitting at the court for a couple of months. When a trial is listed, the matter should be ready to go. And that's why that order is specifically made there. The next question that I raised is medical material, and I've recommended there it's very important that practitioners, plaintiffs should inspect it. If it hasn't been produced, you should preserve your right by lodging an objection, as I've said. But I also have added another point there. Be cautious when you're objecting as to the grounds of objection. Just don't throw in anything you like in the letter of objection. Often happens. You get, we claim privilege over the material and it's got nothing to do with privilege because that is the grounds of your objection. And many times we are told on the morning of the objection hearing, oh, well, it's not actually, the objections aren't in what's in the letter sent to the court objecting, the real grounds are this. So give some care and attention to what you're putting in as the grounds. The last thing I want to just talk about is when the objection process comes up. And that's remembering that the onus is on the issuing party with a 42AA to establish the legitimate forensic purpose as to why the material is sought. Now, you will be familiar with the authorities in this area. Probably the best one for you to look at if you're not sure of some of them, and the one that's probably most often quoted, is Woolworths and Sevilla. The citation for that is 213 VSCA 270. That authority sets out what are the principles in relation to material and the access to material and legitimate forensic purpose, and the test that is required. But it also discusses, importantly, the material that's available. Now, if you've issued a subpoena and objection's been taken by say, the plaintiff, and you're the defendant, remembering the onus is on you to establish the legitimate forensic purpose. How do you do that? Often, it's done, unfortunately, by counsel appearing for the defendant, getting up and making submissions, and that's it. There is no other material before the court to assist the court. Sometimes we don't even get submissions. It's just taken, well, we think there's a legitimate forensic purpose for this reason, or we think we might find this in there, or whatever. There's nothing to assist the court. The court has to have something if you want to really establish what that purpose is. And you should do that by way of affidavit and appropriate exhibits. In Sevilla, paragraph 33, Court of Appeal discussed that as to what was available for the judge in the first instance at the county court. And it said at paragraph 33, in this case, His Honour said there was no evidence before him which enabled him to consider whether there was a legitimate forensic purpose in seeking access to material. It went on to say, and that was a serious injury matter that had gone on, even if the judge had read Sevilla's affidavit, that affidavit made no claim in relation to some of the matters that were in dispute, which was wheelchair bound, etc. Court of Appeal went on to say, furthermore, and this is really important, furthermore, although Sevilla had provided many medical reports to Woolworths, they were the applicant and defendant in the serious injury, none of those reports were placed before the judge in support of the alleged inconsistency. So no evidence was there. So I emphasise that if you're going to try and argue the legitimate forensic purpose, the court has to have something in front of it to be assisting it. The affidavit needs to contain relevant material. We haven't got time to go into affidavits, but often the affidavits will fall in, unfortunately, will not be well prepared. We get the sort of table tenors version of he said, she said, I said, back and forwards, and all you get is paragraphs saying, I sent an email, they replied, I sent, they replied, we get all the emails, or we get the kitchen sink approach with one with everything in it, and you get 100, I've got affidavits with up to 1,000 odd pages delivered the night before. Most of it's got no relevance to what we're being argued, but a well-prepared affidavit with appropriate exhibits will strengthen your case enormously, because there will be in front of the court, in front of the person hearing it, a material which you can then use to say, That's the legitimate purpose, forensic purpose. That's why we're doing it, as distinct from just hearing something from the bar table. So equally so, an objecting party can also benefit from putting affidavit material in if they think it's relevant. So look, that I hope assists you all in relation to subpoenas, the practical side, what the rules are. Rules, as you can see, at times are a bit unclear, but if you follow what I've suggested by the clear path down 42 and 42A, you consider what the practical steps are for you to do. I think that will give you hopefully a great deal of guidance and assist you in relation to the issuing and use of subpoenas in the future. Thank you for your time.
Thanks, Jim. There's a couple of questions that have come through. I'm conscious we've been at it for an hour, but if people can just bear with us for a couple more minutes, it might assist, I think, if these can be answered. Jim, one of the questions that's just come through now is if the subpoena records have not been produced by the production date,
yep,
and an objection is taken because of the non-compliance to protect the right to object, once the records are eventually produced, is there a time then for the plaintiff to review those records, or does it just proceed to a directions hearing?
Yeah, normally what we will do in those instances is that when the material comes in, if it's medical and other records, we'll allow the plaintiff the right to look at that in accordance with the 14-day requirement. If it's other material, then they won't have a right to inspect it at that point anyway until it comes to hearing.
Okay, thank you. One of the other questions was, for 42B and C subpoenas, which are the subpoenas to trial, how are the parties best to check with the court as to whether they've actually arrived?
Yep.
And the answer to that, while we've been online, I've checked with our subpoena team, unless you're probably best to call is the answer. If you've got time, certainly you can email, but normally if this is just prior to trial, and of course these are subpoenas for trial, you're best to just call up. The phone number is 8636 6525, but you'll find that on our website, so you could just call to make sure that those subpoenas actually have been produced. And then another question was just clarification in relation to the timing of the Order 42A subpoena. So they're the early return subpoenas to registry. Under the new timetabling orders, generally the orders we're making now are 2 weeks after the exchange of material. So when the material is exchanged, important that you look at the material, see if there's anything in there that you want to subpoena for an early return, because you've got 2 weeks to do it. Jim spoke about the 6 weeks it takes really for the documents to be returned and that objection process and inspection process to time to permit that. So that way then the material then should all be in by the time of mediation. And of course the emphasis of the court at the moment is very much on cases being fully prepared for mediation. That then means the best prospects of a resolution can be achieved if all the material's in at the time of mediation. And of course it's in everyone's interest for that to occur. So that's the reasoning behind that. There's a couple of other questions that are coming through, but I'm conscious of time. What we'll do is we'll send a link. Someone clever at the court will work out how to do this. We'll send a link in respect of both the slides that Judicial Registrar Gary has prepared today, which have really just been very detailed on what the rules are. But again, it's always important to go to the rules. So hopefully that will be of assistance to you. So we'll send them through. There's been a recording session 2 that we'll work out how to put online for those of you who want to go back to listen to it again or share it with others at your law firms. So we'll do that. And then if there's any other questions, then I'm sorry we haven't had time today, but hopefully going back and looking at the rules, looking at the practice note. We also mentioned earlier that we'll update the subpoena practice note. So hopefully that will assist further, but otherwise get in contact with my associate Rabia and we'll do what we can to assist any other queries. But thanks everyone for joining today and hopefully it's been helpful and practical.